Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. In this video, we are going to learn a case law on the information to be produced before the court before awarding death sentence. Of course, it's the duty of the prosecution. When the prosecution proposes death sentence, so they must produce the information about the background of the accused persons. This is what is stated by the Honorable Supreme Court of India, two judges bench, Justice K. M. Joseph and S. Ravindra Bhatt. In the case of Vikas Chowdary versus the state of Delhi, Vikas Chowdary and another versus the state of Delhi, in the criminal appeal number 2277 by 2022 on 21/4/2023, just 2 days back. So the bench held that in heinous cases, of course, death penalty will be awarded only in heinous cases or one of the rarest of rare cases. So in heinous cases where the death is unwarranted, where the judge supposes that death is the only punishment to be given to him, the prosecution must produce all relevant material to assess the mitigating evidence in against the so-called accused. Please remember, mitigating evidence in favor of the accused. So you have to give all the types of evidence about the previous conduct and character of the accused person, whether he deserves death sentence or not. Simply saying that it is one of the rarest cases is not sufficient. You have to bring out information regarding the antecedents of the accused also. This is the important point in this particular case. So going to the facts of the case, Mr. Vikas Chowdary and Vikas Sidhu, both of them allegedly kidnapped an 18-year-old boy on 18/1/2003 and they have telephoned to the father. They have asked for the ransom. We will say under the double kidnap chesi, double blackmail chesar. Ransom ultimately killed him by the strangulation. Itla medaka taadi champesar. Tip top case. Then actually after this killed by strangulation, and they have burnt the dead body to screen the evidence. Right, okay, father went there, he has given a case, this is it happened in Delhi. So he gave a case of man missing about the child, he was not traced. Ultimately, the fact came to light and the accused were arrested on 9/5/2023. So first month lo incident jarigite, fifth month lo arrest ayyaru. So the accused were charged under 302, 364A kidnapping, 302 murder and 120B. So that is conspiracy, 201 screening of evidence. All these sections, important sections were framed against the accused persons, and the chain, gold chain and also motorcycle of the deceased person, they were also recovered. There was ample evidence and the trial court awarded 30 years of life imprisonment. 30 years of life imprisonment to the accused persons. Right? So normally they have pursued the High Court. High Court also did dismiss the appeal. Now the matter has come before the Supreme Court. Here Supreme Court verified the previous conduct or previous antecedents of the accused person. So Supreme Court came to know that the appellants are young, educated, having educated background and enjoy love and affection of the families, no previous convictions. So there is a probability for them to change their mentality. But still, they have committed kidnapping. They have robbed the person, murder for gain, and they have burnt the dead body. What more is necessary? Of course, it is for the Supreme Court. Now, we can come to the points. So, here the important point is the prosecution, they have got a bounden duty to prove the conduct. So this was stated in the famous case of Bachchan Singh versus Union of India 1980, and the court placed reliance on two more cases also. They are Manoj versus State of MP 2022, Union of India versus Sridharan alias Murugan 2015. So where the special category of offences, that is rarest of rare case, all these things have been discussed. Anyway, since there are no previous convictions to the appellants, and 30 years is not the required period. Anyway, Honorable Supreme Court of India reduced it into 20 years and thus allowed the appeal partly. So important point is the prosecution has to produce evidence about the conduct and the previous cases of the accused person. If you know this much, it is sufficient. Thank you.